Good morning. We are live in Senate Economic Development, Housing and General Affairs. It's Friday, February 23rd. And we have all morning devoted to age appropriate coding, kids code. And to remind myself and others, we don't have floor at 11:30, so we'll be going straight through to noon. For our first hour, we have Rick, who has not been in our witness chair, is a new member of Legislative Council. I will say, to embarrass him, as we were going through the various demographics represented in here, I said something about where my family's from, and Rick's father is from Lahore, pre-partition, India, the same as my father. So we found out we have something in common, and I'm gonna help Rick spread his wings about the Indian person here in Vermont, which I don't think we got to do in Texas as much. So.
Well, yeah. Thank you. Yes, I've not been. I've been waiting for this committee to call my name.
Well, we did call your maiden name and you did not respond.
Well, I don't know if that's true. It wasn't because I didn't want to come
You
here,
didn't, you responded, but you were not there.
but well,
Not available is different because he's learning how tight his schedule is.
Right.
Very quickly.
So Rick Sagel, Legislative Council, thank you. It's nice. I came in early on to meet you all, but have not been on camera or in the hot seat. So thank you for having me here. And yes, the Madam Chair and I, maybe we're distant cousins.
That's probably.
We probably should do some research on that.
I don't know, but I can tell you that your great great grandparents are very amused. That this is where you.
That's right. That's right.
And of course, Vermont fault.
And so
Yeah,
Vermont,
I know,
right,
it's
right,
just
yes.
astonishing, isn't it? Right.
So I think most of you know this. I am newish. I'm going to stop saying that at some point. I came here in October just for this job. Actually, wanted to move to Vermont, and this job got me here. So I'm very happy so far, and love the job, and love the work I've been given. Which today is Senate Bill 289. The draft that you all should have is 1.5. So this is. I'm going to share my screen. If you don't mind.
Good segue.
I've had so much time to work on my presentation. In other committees, I've been warming up for this committee.
Yay.
So this is the age appropriate design code, kids code for short, is maybe the slang term for it. We don't use that term by the way in this bill, but
Right.
So we are in Title IX, and this is it's only 22 pages. I know this committee has taken up bills that are 100 pages. So you see the 22 and you think this is not that long. It is not, however, it's very dense. And I have an hour here to go through it. And if I were to read this straight, which you all don't want, but if I were to do that, I don't know if I'd get through it in an hour. So with that said, I am going to summarize a few things that I think is maybe not, and I don't want to say the word important, like the first term here, affiliate. Well, I think we all know what affiliate means. There's nothing special about this definition. So that's one example. I'm going to kind of skip through that definition. Subdivision 2, age appropriate, is very important. So it means a recognition of the distinct needs and diversities of children at different age ranges in order to help support the design. And these next three phrases, the online services, products, and features, this is used throughout the statute. So it's important to understand that too. In order to help support the design of online services, products, and features, covered entities, which I will also define here in a second, should take into account the unique needs and diversities of different age ranges, including, and there you have different developmental stages. Now, this age appropriate term is only used once or twice in the statute. There, I'm going to point out later on when it is used. So it's important to know these age ranges, but it's not really the most critical part of the law, if that makes sense. Subdivision 3, a child is a individual under the age of 18. Collect is what you think it means. Buying, renting, gathering personal data. This includes receiving it either actively or passively, or by observing the consumer's behavior. A consumer is a person who is a Vermont resident. Okay, covered entity. So this is the start of a pretty important definition A covered entity includes basically every type of business you can think of: a sole proprietorship, a partnership, an LLC, corporation, association, or really any other legal entity that is organized for profit. So this does not necessarily include nonprofits, and I'll get to that here in a second. Because is a nonprofit organized for profit? No. But it doesn't explicitly say nonprofit, right? It's something to think about there. Part B, this is a affiliate of a covered entity that shares common branding with it. Common branding, again, this is pretty general. You need a shared name, service mark, or trademark that the average consumer would understand that two or more entities are commonly owned. For the purpose of this subchapter, for a joint venture or partnership composed of covered entities in which each covered entity has at least 40% interest in the joint venture or partnership, and each covered entity that composes the joint venture partnership shall separately be considered a single covered entity. I think this is to avoid a company that.
Right. Well, I don't know if other.
I don't
finish
know.
that sentence.
My guess here is this is to ensure that if you have a subsidiary or if you have a company that is not well known, that's working with another company and they're a quote unquote joint venture, it shouldn't mean that that lesser known company that is not named in the branding is excused from being.
Except from these
Spinning off
requirements.
your
They're still
Yeah.
covered. They're
Okay,
still part of
good.
the joint
That
venture.
makes sense.
Subdivision 7, a dark pattern. Y'all probably have dealt with this, even if you don't know. When you are on an app or when you are on a website and you subscribe to something or you buy something, website apps can be designed to nudge you to do something that you maybe aren't aware that you're doing. So this defines dark pattern as a user interface designed or manipulated with the purpose of subverting or impairing user autonomy, decision making, or choice. So this does not imply negative decisions are made. However, the usual definition is it's like a kid on an app that buys extra coins. They click the I want to use my parents' app store account to buy something, right? Subdivision 8, default. We all know what default means, the pre-selected option adopted by the covered entity. De-identified means data that cannot reasonably be used to infer information about or otherwise be linked to an identified or identifiable consumer or a device linked to such consumer, provided the covered entity possesses the data. A, takes reasonable measures to ensure that the data cannot be associated with the consumer, publicly commits to maintain and use the data only in a de-identified fashion and not attempt to re-identify the data. Contractually, I don't know why I say data and data. I'm sorry. I'm doing this.
It's
I
good
didn't
variety.
even notice.
Oh, I'm totally doing. Contractually obligates any recipients of the data to comply with all provisions of the subchapter. Subdivision 10, the derived data means data that is created by the derivation of information, data, assumptions, correlations, inferences, predictions, or conclusions from facts, evidence, or another source of information or data about a child or a child's device. Okay, legacy. Sorry, I'm not looking at my
Yeah,
computer here. Yeah, I'm looking at this, but let me look at my screen. Legacy means any online service, product, or feature that is likely to be accessed by children and that is offered to the public before July 1st, 2024. So this is important as this act applies to obviously take effect July 1st, it passed July 1st, 2024. So if a company has a product right today that's being offered to the public, it would be a legacy product. Okay. Now, if it's continually offered after July 1st, it would still be considered a legacy product. But look at subdivision 12. Non-legacy means any online service, product, or feature that is likely to be accessed by children and that is first offered to the public on or after July 1st. So first offered. So if you create a brand new app on July 2nd, it would be non-legacy. If you continue your app from June 30th to July 2nd, it would be considered legacy.
And did we determine that offered to the public means that offered for purchase, offered for free? not like necessarily just offered to a trade group of some sort, so it has to be.
Right, I think we can, no, I think
Okay.
I think the understanding is that this is just, it's available to be accessed by the public
Okay.
on a device or on a computer.
It could be like what we consider a public accommodation, perhaps, which, I just don't know like what we mean by public.
Or public. Yeah, good question.
Are we doing questions as we go?
I think, yeah,
Is that okay?
that's okay with me.
That's, it's your
Because I have
commitment.
some back questions.
Oh,
but I'll-
okay.
But I can ask. So should we say, or, so you chose to say offered, available? Because to me, available is more passive. And offered implies some action. But if a kid can get to it. That's what
But
we
they,
want.
well, that might, this partially was for our local tech companies. Who, didn't want to be penalized unintentionally, so I wonder if for them available to. I think that's still a worthy thing to consider, I just wanna let people know where this came from.
That are broadcasting online.
Well, the meeting that took place to help them understand the language that Center for Humane Technology helped conduct our former VEPSI guy.
Yeah.
With that hula. So there, and I know like Brattleboro has, a little tech hub, like there's tech companies that have global reach. I don't.
Yeah, it's kind of interesting because the tech companies I know of are doing things. As much outside of the state as inside.
Oh, yeah.
Yeah, so
What's your
they're-
tech company?
Right,
Yeah,
if they just, when they gave their input, I think it was from the perspective of any small tech company that's not a Silicon Valley giant. That, is a kind of bigger player in this, and they're not constantly thinking about how an algorithm could bring more children into their product, but so they want to be kind of, they want to make sure that if something unintentional happens, they have a process to cure that and to sort of.
Oh, so they would cure.
Yeah,
Okay.
so we can keep looking at the language here, I just want to let people sure that came from. And I hope maybe I characterize that, okay, great.
Madam Chair, I have to go to this. All right,
Okay,
I'll be right back.
so last help.
Yeah, really.
Shut up.
So you'll be back probably half an hour.
No, I'm gonna be back faster.
Oh, okay,
This is very important. Thank you very much. I'll see you shortly.
Shall I continue?
yes.
Okay, so did legacy, did non-legacy. 13. An online service, product, features, and we use this phrase throughout the statute, means non-legacy. So I added that recently because we had this discussion behind the scenes about legacy versus non-legacy. And I wanted to make sure that when we use this phrase, this statute is applying, in the most part, to new applications being offered to the public or being available to the public. So if we don't use the term legacy, it means non-legacy. Okay, so online service, product, or feature means non-legacy and does not meet any of the following. A telecommunication service as defined in federal statute, a broadband internet access service as defined in 3 VSA 348, or C, the sale, delivery, or use of a physical product. 14, personal data means any information, including derived data, that is linked or reasonably linked alone or in combination with other information to identified or identifiable consumer. It does not include de-identified data, which we defined earlier, or publicly available information. Now, we define this, yes, you were right, okay? As used in the subdivision, publicly available information means information that is A, lawfully made available from federal, state, or local government records, or widely distributed media, and a covered entity has reasonable basis to believe the consumer has lawfully made available to the public.
Everybody, we're free game that we are legislating. Because that is known to the public.
Right, but there are things that are public that people might not necessarily know that are public, like driver's license information,
Oh, yeah,
things like that.
anything's registered.
Arrest records.
So we'll talk more about that.
Yeah,
Right?
yeah.
You may not be able to get the information, but the police can. You can't get, you're not supposed to be able to get, who has what license plate.
Right, now you can't, right, but you used to be able to. Or the,
Police can.
there's records that the driver's license folks have that used to be available to the public, but now they're not.
You know,
Oh, no, totally,
Yeah.
but I just wonder if there's other things like that.
Right.
So that's worth a conversation.
Yeah, and we can figure out who can answer these
Yeah.
questions. We have some professors coming in.
Great.
So, yeah.
and yeah, widely distributed media, I mean, is that a viral image, you know, that's on
Or
on
TikTok.
TikTok? Yeah, like, is that, is something that gets shared a lot, is that widely distributed? So just something to think about.
Something you put on Facebook.
Yeah, what makes it widely,
Widely
right?
distributed.
But if your Facebook is shooting your friends, you know.
Yeah, if you've got it, okay, yeah, you've got it closed.
Interesting.
Yeah.
Okay.
It's that, yeah, that needs to be maybe further defined. And B, a covered entity has reasonable basis to believe a consumer, sorry, I already said that, has lawfully made available to the public. 15, precise geolocation means any data or data that is derived from a device and that is used or intended to be used to locate a consumer within a geographic area that is equal to or less than an area of a circle with a radius of 1,850 feet. That feet was not chosen by me. I'm sure there's a reason for that. I don't know the reason, but
It's a good question. Going to subparagraph A is lawfully made available federal, state, or local government records for widely distributed media. Does lawfully refer to widely distributed media?
it's lawfully stating, I'm sorry.
Is lawfully made available, does that apply to widely distributed media as well as to made available from?
I would say no. I would say those are two different.
So if, for example, you have something like President Trump's tax records
Mhm.
that were published in the New York Times and obviously were widely distributed, does that mean that that is available and should be available regardless of any privacy restrictions contained in the statute?
It's
Could the same apply if they were your public tax records or Senator Harris's public tax record? Would that apply, intend to apply the way that reads?
At the very least, it's vague. So if that's concerned, you know, I think we should make that at least a separate subdivision. If you want it to be separate, if you want it to be combined, it's lawfully made, then we need to probably write that
I
down.
really want to see what's in Senator Harris's tax records, so I'm happy to address
Let's,
that.
let's not mess with
We
that.
can talk.
Okay.
Okay.
Yeah, I have a question about that. So is this the child's data, like, when you say, I believe a consumer has lawfully made available to the public, is that the child making something available?
Well, not yet, right? So we haven't gotten to really
Okay.
the scope of this.
But
So
the
for a consumer is anybody, right?
Okay.
A child is under 18.
Anybody in
Consumer
Vermont.
is- Yes,
Okay.
consumer is anybody in Vermont. So yeah, so far like, this applies, right, to everybody, but you'll see in a second how it does change.
And just not,
We're still in the definitions, right? So
I know,
it's- yeah.
but it's, those are definitions are important, so, and
Yeah,
just
yes,
in the geolocation, I would just ask that we ask the, online betting folks.
I was gonna say, I think
The
Oh, yeah.
geolocation
as
is,
this is.
I
fine
used
by
to
your
call
thing.
my credit card company to tell them I was going to Nevada to, a
Right.
concert. They said, don't bother, we know where you are,
Right,
which is
Right.
kind of scary.
Right,
yeah.
and actually, we probably wanna make this bigger rather than smaller. But we can talk.
Okay.
Okay,
It's scary for adults, how
right,
much is out there and is now.
yes.
Subdivision 16, process of processing. Just the processing of personal data, collecting, storing, using it, disclosing it, analysis, deletion, modification, or otherwise handling of data. So nothing controversial there, just that's what that means. 17, product experimentation results means the data that companies collect to understand the experimental impact of their products. Profile or profiling means any form of automated processing of personal data to evaluate, analyze, or predict personal aspects concerning an identified or identifiable consumer's economic situation, health, personal preferences, interests, reliability, behavior, location, or movements. It does not include process information that does not result in an assessment or judgment by a consumer.
And this is all consumers.
Yes.
So will this stop every time I buy something online, that product continually sending me emails with, no, it won't
It's not
stop.
gonna
This bill will not.
I can't stop those.
That's a
political
whole different bill.
campaigns.
That's a whole different bill. We don't have the rules.
But at least we have definitions for it.
We do.
We do.
2025. 19, okay, this is a very, very, very important definition. Reasonably, which I have trouble saying, reasonably likely to be accessed. I'm gonna probably shorten that to not trip myself up every time. It means an online service, product, or feature that is likely to be accessed by children based on any of the following indicators. So this one, you may have questions about. Part A, the online service, product, or feature is directed to children as defined by COPA, the federal law, and the FTC, implementing the act. B, the online service, product, or feature is determined based on competent and reliable evidence regarding audience composition to be routinely accessed by an audience that is composed of at least 2% of children 2 through under 18 years of age. So here you have, kind of the narrowing the scope a little bit, that the feature, the service, is featured by an audience that is at least 2% of children between those two ages. So the company would need to do some data assessment to say, like, what does our audience look like? How do we know how many adults versus children are using our app or using our website? There's more here. Part C, the online service, product, or feature contains advertisements marketed to children. That is quite broad.
So that doesn't mean marketed to children and others, it just means marketed at least to children.
Yeah. So if there's one advertisement that is directed towards children, like Legos or what kids buy these days, Bluey.
They have little pink unicorns and things.
Into
Yeah.
unicorns. I have a 7-year-old. I think I would know this. She likes unicorns. So yeah, probably. So yeah, I think that, is fairly intentionally broad to include those types of services in this covered entity. The online service, product, or feature is substantially similar or the same as an online service, product, feature subject to subdivision B of 19. Trying to think why the importance of that. It may not be doing much. Subdivision D, I will look at that after this. Subdivision E, the audience of the online service, product, or feature is determined based on internal company research to be composed of at least 2% of children 2 through 18 years of age, or the covered entity knew or should have known that at least 2% of the audience of the online service, product, or feature includes children 2 through under 18 years of age, provided that in making this assessment, the covered entity shall not collect or process any personal data that is not reasonably necessary to provide this service or feature for which a child is actively and knowingly engaged. So when you see that phrase reasonably likely to be accessed, it's a pretty broad net, right? So just kind of maybe keep that in mind as we go through this. Subdivision 20, sell or sold. Means the exchange of personal data for monetary or other value consideration by a covered entity to a third party. It does not include the disclosure of personal data to a third party who processes the personal data on behalf of the covered entity. The disclosure of personal data to a third party with whom the consumer has a direct relationship for purposes of providing a product or service requested by the consumer. The disclosure or transfer of personal data to an affiliate of the covered entity. The disclosure of data that the consumer intentionally made available to the general public via a channel of mass media and do not restrict to a specific audience. Or the disclosure or transfer of personal data to a third party as an asset that is part of a completed or proposed merger, acquisition, bankruptcy, or other transaction in which the third party assumes control of all or part of the covered entity's assets. I'm sorry reading this word for word, but some of the stuff is. So,
I'm going to have a question on D.
okay. Well,
You wanna know it now?
sure.
Sometimes people regret what they shared. Especially, when they get older. Is there any provision to claw back? It's similar to the tax return thing, but, is there any provision anywhere, not maybe just this bill, but anywhere to get data back or delete data?
So definitely, not in this bill. Is there another bill? I don't know.
Okay, or
But
another law?
yeah, but if that's something that you think the committee should consider
Well, I
to
just,
put it in this bill or.
to me, the way you protect data is to delete it. I mean, that's the ultimate protection, is delete it. And the data often is only necessary for a certain period of time, maybe 6 months. And it's not necessary to be saved. And there are lots of breaches, however much language we put in a bill, in a law, there's going to be either intentional or unintentional breaches. But when data is deleted and really deleted, there, you reduce the likelihood of that. And I think the European standards have some deletion.
Yeah.
Ability, so that you can say, I want my data deleted after 6 months, and then
Right.
the response will be, oh, but then you won't get all these websites that we know you like. And you just say, that's okay,
Yeah.
I'll figure it out.
Yeah.
But I think that's really important in consumer protection.
Yeah.
But if you have something that has been deleted under a provision like that, what if the information has been shared somehow, otherwise obtained during a period of time
Right.
that the entity that you're doing business with has the data? You still haven't deleted anything.
Well, you would have at least deleted it from that massive database, which is a database that's accessed by others.
Let's continue to talk about it. I came in halfway, so I don't wanna say too much. I think it's a bigger fight, and you'll see that these definitions help us later from keeping them from getting the data in the first.
Which is
Yeah,
the best.
Well,
but I hear what you're
As
saying.
good as we go
Yeah.
through to understand what
Exactly.
the meaning doesn't do
Oh, yeah.
what the intent is.
Right,
It's probably useful to identify it earlier rather
Yeah.
than later in the discussion.
so I might have missed something there, but I think deletion's very interesting. It just seems like a much.
I think what you see in this bill is interesting. Again, this is mostly model language that I've tried to, put into Vermont style. What's interesting here is you have a scope that broadens and narrows. So you have this language that seems to apply to all consumers. And you keep asking, oh, is this gonna help adults? No. Because it sounds initially like, hey, this is gonna maybe be way too directed to all consumers. But you'll see here, we're about to get to out of the definitions, you'll see that now we kind of get more specific. What are we, trying to get these businesses to do to protect kids specifically? So, but we haven't been, but now maybe we have language for future bills that may address.
Yeah, or, and maybe the data removal is just for kids.
Yeah.
Well, I'm thinking about the kid who gets caught up in neo-Nazi things when they're 15 and 16. And then sees the light somewhere around 21, goes on to try and run for political office. Or get a job in the police department or anywhere. And that's out there, and once it's out there, you're branded with it for the rest of your
Yeah.
life. And for kids, they get caught up in all kinds of things and testing, and that's,
And they should be able to explore as children
yeah.
too. That's part of being a child.
The definition of a child, again, is someone under 18, right?
Right.
So we certainly have 18-year-old murderers who were tried as adults.
But that's a justice issue, not.
And their records get sealed,
Data.
right? If you're, and I thought about, if you're making a mistake as a kid, at least in Texas, I assume it's here too. If you're 16 and you, not murder somebody, but if you steal something or you smoke marijuana illegally, like that record would be sealed after you turn 18. So
Certain
maybe
records
that's,
obviously would not be.
right.
Yeah.
If you're trying to
There's-
adult, no,
But
but
then there's expungement, which is deletion. So
Right,
they
but
are
if-
separate things.
If you put it on your Facebook, I can expunge your criminal record. But everything you thought when you were 16 or 17 is out there in the ether and can be accessed. That's why they tell us everything we say in this building is out there somewhere.
Oh, I totally understand, but there's certain databases that are connected to each other that are talking all the time. And getting a kid's data out of that would be meaningful, but we.
I just wanted to time check,
Okay,
yeah,
30
half an
minutes.
hour more.
Let's go.
Yeah.
Let's roll.
These are not, off
Yeah.
topic by any means, but we just want to get
Yes.
through the language, then we have some experts coming in.
Did I get disconnected? Oh, maybe not. Okay. Shows on, if I didn't get disconnected, let me know.
Okay.
So we're almost done. Share means sharing, renting, releasing, or disclosing, disseminating, making available, transferring, or otherwise communicating orally in writing or by electronic or other means that consumers' personal data. My Zoom here is showing me 3 connecting, so I'm able to Wi-Fi for a second.
I've had trouble with my wife just being very slow.
Yeah,
The Wi-Fi router in this room didn't work, so they moved it down the hall.
okay.
Okay, well, I have to keep restarting my iPad.
Okay.
The other-
So yeah,
Oh, we
sharing.
have paper copies, so.
Yes.
I'll just do
I'm
that for
back.
the public.
And you're right, this is on our website.
Yes.
Draft
Oh, there we go.
I'm back.
Okay, we're back, cool.
They didn't want to never. Somebody didn't like what we were saying in this room.
That's true. They can do that.
Or otherwise, so we're on sharing, to a third party for cross context behavior advertising. Again, this is not maybe too important here, but that's the definition of share. 22, third party means a natural or legal person, public authority, agency, or the body, other than a consumer or the covered entities. Okay, now, the scope and the exclusions. So remember earlier, we defined covered entity as basically anybody, right? Except maybe a nonprofit. So a person is considered a covered entity for the purpose of the subchapter if, 1, they collect consumers' personal data or has individuals' personal data collected on behalf of by a third party. 2, alone or jointly with others determines the purposes and means of the processing of individuals' personal data. 3, operates in Vermont, and alone or in combination annually buys, receives for the covered entity's commercial purposes, sells or shares for commercial purposes, alone or in combination, personal data of at least 50% of consumers. So wow, and immediately the scope narrows quite a bit. So if you're just a small company in Vermont that sells widgets and doesn't care about personal data, you will not be included in this. You'll have to hear from testimony about, maybe from the Attorney General or somebody in the county, what kind of businesses would fall under this definition, because I don't know. But it certainly is very, very narrow. The subchapter does not apply to, I'm on
May I ask a question again, in terms of the meaning of operates in Vermont? Are you dealing with a company that may be headquartered elsewhere that is electronics supplier, for example, Google? Considering it operating, meeting all 4 of these conditions, including operating in Vermont, because it transmits information that's received by consumers abroad.
Yes, I believe that's why you have companies that don't want this bill, large companies that are trying to maybe change the language here because this would include them. To me, operating in Vermont means it is accessible in Vermont.
I stand on the border of New Hampshire, and I'm one of these companies, and I yell loud enough so that it's heard in Vermont. Am I operating in Vermont?
Well, you still have to have
Meaning of the way this is structured.
you still have to be an online service product, right? So if you're just yelling, then no. But if your app reaches across the border to someone in Vermont, like sports betting.
And if you're within 1,850 feet,
There you go.
that's.
Where does it say?
Well, because again, so this is a weird narrowing and broadening scope. This act just would apply to online services, products, and features. So if you're just a offline, I don't know, I can't even think of what it would be. You're a bookie, right? And you're taking bets offline. Would you be operating in Vermont if you're yelling across the state border? No. Because you're not an online
Basically, what I'm
service.
getting at is if you're that bookie who is operating online in New Hampshire, and what you do is heard in Vermont, but you're not operating in Vermont, you're not located in Vermont, are you covered by this? That's what I'm really trying to get at.
If you can be accessed by somebody in Vermont,
Right.
then I think you operate in Vermont.
While they're within Vermont and a consumer here is also defined as a Vermont resident. So when you put these together.
If some Vermonters
Yeah.
make a book, then
No, if it's a New Hampshire person making.
No, then that,
We
But
can
they-
circle it and make sure
I'm
there's.
just trying to understand the
I'm
meaning
sure
of
for
definition
other
and
tax
what is not included.
law reasons we have operate somewhere, but let's move on.
he's doing sports betting, we know.
Right, exactly.
Okay, the subchapter, page 9, the subchapter does not apply to protected health information that is collected by a covered entity or a covered entity associate governed by the privacy, security, and breach notification by the U.S. Department of Health. 2, a covered entity governed by the privacy, security, or breach notification rules issued by the U.S. Department of Health and Human Services. And this is all health protected information.
Oh,
That's interesting children.
this is-
Yeah, so let's go down, right, so that's.
This is him.
Yeah, so 2449C, the best interest of children, all covered entities that process children's data in any capacity shall do so in a manner consistent with the best interest of children. What does that mean? It means the use of personal data of a child or the design of an online service part of a feature that, 1, will not benefit the covered entity to the detriment of the child. Pretty vague, but I think intentionally so.
And I just wanna say, we do this in family law all the time in Vermont, so we're not gonna get more specific than this. We have talked a lot in our judicial branch about what the best interest of the child is.
Okay. And 2, will not result in A, reasonably foreseeable and material physical or financial harm to the child. B, I'm just gonna get out, I can't say reasonably, foreseeable and severe psychological or emotional harm. A highly offensive intrusion on the reasonable privacy expectation of the child, or D, discrimination against the child based upon race, ethnicity, and the other protected classification.
While we're on this list of discriminated protected classes, it's gonna come up a lot, and I asked Rick currently to mirror what's in the Equal Rights Amendment bill, because as they take that up, they may look at other categories, but I wanted us to, that's kind of a judiciary conversation. So I wanted to start with what's in the ERA, since I don't know that we've decided we need a common set of characteristics when we pass any bill, but that seemed to me a good place to start since it's up for discussion this year.
My question is, when we were listening to the young people,
Mm-hmm.
the real harm seemed to come in the emails that say, you put your profile up and everybody says drink, bleach and die. That kind of interaction with your peers.
That's foreseeable and severe psychological or emotional
Yeah,
harm.
but is TikTok, or whoever is X, whatever's, the kids are communicating with each other.
Yeah. That they're not a covered entity,
I mean,
if that helps.
yeah, but that's,
They aren't
That's
creating
the-
a service, product, or feature.
Right. and I can see we
Yeah.
don't want kids being inundated with bikini offers because they
Right,
told a friend online that
Right.
they were looking for a bathing suit.
yeah.
But the real harm, the things that seem to drive kids
Uh-huh.
is the peer reaction, the rejection,
Well, I
and I
think,
don't know how we.
I don't know
do
if
that.
our young people wanna speak. I think what they said is a lot of that comes on top of a system that's making them feel anxious and isolated to sell products or to keep their eyes online. So we aren't taking on online harassment and bullying by other minors, which is a
That's-
harm.
It's-
This is saying beyond that, there is psychological harm happening, because they're being profiled by products and advertisers.
Yeah, can I just add to
Yes,
that? And there's
yeah.
harm that they don't even know.
Right,
Like that the harm from their peers is more obvious to them, but then there's harm that they don't even.
Right,
They're not
but
getting
if they commit suicide because their peers are telling them to drink, bleach and die, which I believe
Yeah,
is
no, that's
one of the
horrible.
phrases we heard,
So
they're not ever gonna know the other harm.
we actually have someone who represents
Okay.
victims of social media coming in, and you might ask some of those questions.
Okay.
I don't think Rick can go any
Oh, no,
further.
I'm
Yeah.
not,
But there might be another bill later on when we try to.
Well, I don't know
Right,
how
cover
to
that.
control that.
The education
Free
committee
speech.
also having a technology conversation. We're doing this piece, which is consumer protection from economic covered entities, not peers.
So yeah, if you don't mind, this is important. I
Yeah.
want to make sure we get to the actual teeth
Right.
of this, the teeth of the bill.
Yeah.
So these, if you are a covered entity, which we now know is fairly limiting, you must complete what's called a data protection impact assessment, DPIA. So this is, the work that a covered entity would have to do. And if you have a feature or service that is reasonably likely to be accessed by children, which is defined above, you must make this documentation and maintain it for as long as it's accessed by children. It is a systematic survey to assess compliance with the duty to act in the best interest of children, which is defined above, and shall include a plan to ensure that all of these products provided by the covered entity are designed and offered in a manner consistent with the best interest of children. And here we're going to define what these are here in a second. Such a plan shall include a description of the steps the covered entity has taken and will take to comply with the duty to act in the best interest of children. Review and modify all these assessments as necessary to account for changes in your products within 90 days of making the changes. So if you update your app, you have 90 days to update your DPIA if it's a material update in your app. Within 5 days after receipt of a written request by the Attorney General, provide to the AG a list of all DPIA the assessments with the covered entity has completed. Within 7 days after receipt of a written request by the AG, provide the AG with a copy of the DPIA, provided the AG may extend that 7-day window if it wants. Part 5, configure all the default privacy settings provided to children by the online service to settings that offer high level of privacy, unless the covered entity can demonstrate a compelling reason that a different setting is in the best interest of children. 6, provide any privacy information in terms of service policies prominently, so you can look at it easily without having to dig through it. 7, provide prominent, accessible, and responsive tools to help children in an informed manner required by the AG or, if applicable, their parents or guardians. Okay, subsection B, important. Here's what a data protection impact assessment must include.
And you're gonna see a lot of language repeated, so
Yes, yes.
we'll try to keep it to that first sentence.
Thank you, Madam
It's
Chair.
repeating that list of all the different types of harms that go against the best interest of a child.
It must, 1, identify the purpose of the feature. 2, disclose how it uses children's personal data. 3, determine whether the online feature is designed and offered in an age-appropriate manner. So there you have that definition that we said 0 to 3 or whatever it was, 0 to 5, 5 to 9. If you go back to page 1 or 2, you'll see what age-appropriate manner means. Consistent with the best interest of children who are reasonably likely to access the online product by examining A, whether the design of the online service project feature could lead children experiencing or being targeted by contacts on the online service that would result in reasonably foreseeable and material, physical, or financial harm to the child. Reasonably foreseeable and severe psychological or emotional harm to the child. A highly offensive intrusion on the reasonable privacy expectation of the child. Or discrimination against the child based on race, ethnicity, so
So you're gonna see that list over and over again with different ways they may be harmed by the first line, so we could just do the first line.
yeah, so could permit children to witness, participate in, or be subject to conduct on the online service product. Same language. Whether the design is reasonably expected to allow children to be a party to or exploited by a contact on the online service. Contract, sorry. Important. See, one letter does make a difference.
Yeah.
Senator Clark.
And we never disagreed on the letters.
Oh,
All right.
I'm gonna find it. I'm gonna find it.
We'll find it,
And
yeah.
the
I'm gonna find it.
and the apostrophe.
I just had to call you out there. Subdivision D, whether the algorithms would result in reasonably perceivable and material physical or financial harm to the child. E, whether targeted advertising used by the online service would result in same. F, whether the online service uses system design features to increase, sustain, or extend use of the online service. We call it the scroll, the
Mhm.
forever scroll, I
Infinite
think,
scroll.
infinite scroll, thank you. Part G, whether, how, and for what purpose the online product service collects or processes personal data of children, and whether those practices would result in same. Whether and how product experimentation results or the online product service or feature reveal data management or design practices that result in same.
Those aren't.
Okay, then we have a new subsection here, a data protection impact assessment conducted by a covered entity for the purpose of compliance with any other law complies with this section if it meets the requirements of the subchapter. So if there's a federal law one day that requires these,
That's a good idea.
that would work for Vermont.
Or another state.
Yes, correct. By California. Subsection D, a single TPIA may contain multiple similar process and operations that present similar risk only if relevant online, each relevant online service product feature is addressed separately. A covered entity may process only the personal data reasonably necessary to provide an online service product or feature with which a child is actively and knowingly engaged to estimate age. Sorry, and this is one that we struggle with. It's how you word this. So I tripped up on it. A covered entity may process only the personal data reasonably necessary, et cetera, to engage to estimate age. So you may first use this data if you're doing that to come up with age appropriate age ranges. So that's okay.
Right.
If you're processing all this analytics you get from your app usage, you can do that as long as you're saying, okay, we have 10% of our users are under the age of 18. And that's okay if that's all you're using that data for. That's what subsection means. F, a DPIA created pursuant to the section is exempt from public disclosure pursuant to our Public Records Act. Okay, 2449E.
I'm gonna have a question on that.
You can.
Okay.
Yeah.
I understand why we would want all the detail to be exempt, but whether or not it complies or doesn't comply, could that be not exempt? I mean, somebody's gonna make a determination about whether or not that report is.
The AG.
Okay, so when the AG gives either a check or a minus, can that check or minus be, I think it should be publicly disclosed.
I think we can.
But maybe not.
I think we
I
can
mean,
work
that's
on
just
it.
a-
No, I hear what you're
So the
saying, yeah.
report itself, I think, would be, because it's a government agency
Right.
that's doing that analysis, but the internal documentation the AG looks at would not be public.
Oh,
Their
right,
report
right.
saying the company
Exactly.
X, company
Okay.
X is, which I can't say now, company Y, has failed this.
Funny.
Yes,
Sorry.
I think we know if they're out
Okay.
of compliance.
Okay,
And we can ask the HE that.
If the AG then reports, in a report that's publicly available, the company is not compliant, and the company wants to contest the AG's report, then presumably they've got to go to court to do it. But in so doing, they would have to have access to what's being used against them in order to litigate, I would assume.
They have that.
That's a good question. Yeah, I believe. So we're gonna get to how that relationship between the AG and the companies work, and let me get
Right.
to that, and then
But also, we're talking about exemptions to the Public Records Act, which is different than the parties to
But
it.
what I'm really getting at is there in effect a backdoor intentional or otherwise to that protected information when coming to contest an allegation against a company for a violation?
Let's ask the HE's office.
yeah, that's a probably question for the AG. It's a good question, but yeah, I think there could be. 2449E, covered entity prohibitions. A covered entity that provides the service that is going to be accessed by children shall not, 1, process the personal data of any child in a way that is inconsistent with the best interests of children that are going to access the service. 2, profile a child by default unless both of the following criteria are met. A, the covered entity can demonstrate it has appropriate safeguards in place to ensure that profiling is consistent with the best interest of children. And B, either of the following is true, profiling is necessary to provide service, and only with respect to the aspects of the online service with which a child is actively and knowingly engaged, or the covered entity can demonstrate a compelling reason that profiling is in the best interest of children. And that would be up to the AG to determine what that compelling reason is. 3, process any personal data that is not reasonably necessary to provide an online service product or feature with which a child is actively and knowingly engaged. 4, if the end user's child process personal data for any reason other than a reason for which that personal data was collected. 5, process any precise geolocation information by default, unless it's used strictly necessary for the covered entity to provide the service requested, and only for the limited time that the collection of the precise geolocation information is necessary. So we're talking about tracking here. We don't want apps to track children unless they are give that privacy setting, turn it off, turn it on, whatever the opposite is. 6, process any precise geolocation information of a child without providing a conspicuous sign to the child for the duration of that collection that the precise geolocation information is being collected. 7, use dark patterns to cause children to provide personal data beyond what is reasonably expected to provide the online service. To forego privacy protections or to take any action that the covered entity knows or has reason to know is not in the best interest of children that are going to access the service. Notwithstanding language in this section.
Just ask a question. I mean, they're already. This tracking the parents do, which I think is also kind of weird and helicoptery. So, I mean, we have some tracking that parents would like to defend, but I mean, there's tracking that goes on, so that is okay.
We had that
So here,
conversation. Yeah,
subsection B, let's see what we think about
Yeah.
this.
that's exactly.
Notwithstanding any language in the section to the contrary, a child's location or online activity should not be tracked or monitored by a covered entity that provides an online service, product, or feature reasonably accessed by children unless a conspicuous signal is presented to the child while the child is being monitored or tracked. I think,
This used to
Yes,
talk
I
about
fix that.
parents, and I don't know, Rick, if this was
it
intentional.
was not.
We will look at some language. We were talking about that and something happened.
Yeah. This would be, so
yeah.
instead of covered entity, imagine this saying by a person.
Right, so this
Which makes
allows a
sense.
parent to say, hey, I'm asking you to turn on your Find Me thingy on your phone. And the child knows that they're consenting to that and that their parent is monitoring them.
I think that's actually important.
Yeah, we landed on the side of a parent can't monitor their child without consent in their phone.
Yeah, that's why in fact here, this would.
Yeah. And that's like an open conversation.
Yeah, we should talk
Things
about
of it.
I think
Yeah.
that's
That
great.
might be the
Yeah.
most controversial.
Right, it might.
Yeah, I think we had talked about how the transparency between the two is necessary, where it's not always so much that a child needs to agree, but they need to know.
Right.
And that's really important.
So, right, like a parent can't, the child can say, hey, I wanted to watch that and you're not letting me with the TV parental controls. But the parent's like, I'm gonna do it anyway. So,
Yeah, I need to fix this.
Yeah, and the geolocation tracking
If
does
notice
with
electronically for a
transparency.
child doing it.
the child would have to know that it's happening. So they could say, if you want your phone, I get to know where you are. That they don't get to say, I was watching you last week, you know? And that's like a huge question, you know, but I think it's like, this is about children's rights in some ways. You know?
Absolutely, and I think we can think of
This is such a-
divorce, parental situations and
Tracking another parent.
tracking and there's a lot of
Yeah.
I think that this deserves some conversation because parental tracking, depending on the parent, may or may not be a great thing.
Jennifer, you look like you might want to say something.
No.
Okay, we know your mom, so I'm sure she has too.
Okay, I have 5 minutes.
Yeah.
And then I think I've run a house conference, but maybe they're
Okay.
if the house is still on the floor, I have more time.
Okay, well, we don't necessarily.
Okay, well,
We're
then-
coming to the end, so.
Okay, coming to the end. So data practices, this is important, always important. A DPIA collected or maintained by the AG is classified as non-public data or private data on consumers. B, to any extent, any information contained in a data protection impact assessment disclosed to the AG includes information subject to the attorney-client privilege or work product protection. Disclosure pursuant to the subchapter does not constitute waiver of that privilege. So that may be enough. The AG will know much more than I about that language if it needs to be changed to address your concern, Senator Brock. 2449G, AG enforcement. This is the teeth to the entire bill. The AG may seek the imposition of an injunction and a civil penalty of not more than $2,500 per affected child for each negligent violation of the subchapter. Negligent, again, important word there, or not more than $7,500 per affected child for each intentional violation of the subchapter, plus costs and reasonable attorney's fees for violation. Special revenue fund, skip that. Okay, C, if a covered entity is in substantial compliance with the requirements of the subchapter, the AG must, before initiating a civil action, provide written notice to the covered entity identifying the specific provisions of the subchapter that the AG alleges have been or are being violated. Okay, now we have a bit of a difference here between non-legacy and legacy. If for a covered entity that satisfy the terms of 2449D, which is creating the DPIAs, if they've done that before offering a non-legacy product that is going to be accessed by a child within 90 days following the notice required by the section, the covered entity cures any notice violation and provides the AG a written statement that the alleged violations have been cured and sufficient measures have been taken to prevent future violations. The covered entity is not liable for civil penalty for any violation cured pursuant to the section. So that 90-day time is applicable to legacy, to non-legacy products as long as they did the DPIA before they got the notice. Legacy products, if for covered entity offering a legacy online products, pursuant again to 2449D, before receiving written notice from the AG, 90 days, very similar, that they can still cure it as long as they did the DPIA before they got the notice from the AG. No individual entitlement or private right of action is created by the subchapter, so you cannot sue. You as a person can't sue Facebook or a company for your selling your data under the statute. Limitations. Nothing in the subchapter shall be interpreted or construed to impose liability that is inconsistent with federal law, 47 U.S.C. 230, prevent or preclude any child from deliberately or independently searching for or specifically requesting content, or require a covered entity to implement an age verification requirement such as age gating. This applies to a covered entity. Let me start from the top. A covered entity must complete a DPIA for any new product, service, or feature likely to be accessed by children offered to the public after July 1st, 2024, unless it is exempt pursuant to B, which this act does not apply to an online service, product, or feature that is not offered to the public on or after July 1st. So if you shut down your software before this act takes effect, you can't be held backwards responsible for data before July 1st.
I want to make this section, I think, consistent with the other ones as well. Rights and freedoms.
Oh, okay. Yes. With that ERA language or the
Yeah.
equal rights language, yes. Okay, finally, rights agreement to children. I'll just update that language. 2449K rules. The AG may adopt by rule any standards or procedures the AG needs necessary to implement the policy subchapter. The rule shall be consistent with the rules, regulations, decisions of the FTC, the FCC, and with federal court interpretations of the FTC Act as amended. This act should take effect July 1st, 2024.
May I ask a question?
I think let's make this the only question because our.
The question goes back that says no individual entitlement or private right of action is created. Does that mean that a parent, for example, was aggrieved and the Attorney General does nothing, has no right to act under this law?
Under the statute, right? They could maybe sue them under a different consumer protection law.
Okay, I'm sure people have more questions, but we'll keep revisiting them. And thank you, Rick.
Sure.
You can stay if you don't have anywhere to go yet, since the house is still on the floor, but we'd love to start hearing from other witnesses.
Sure.
Ritual. So to the extent, you can stay in the witness chair if you'd like, unless you want to be able to see people better.
Yeah, let me also do mine, because I'm chair.
Okay. Our first witness is the Honorable former Congressman Dick Gephardt, co-chair of the Council for Responsible Social Media. Thank you so much for being with us.
Thank you so much. It's a great honor to appear before you today. I thank you for this opportunity. I want to thank Chair Hinsdale and fellow committee members for us to be able to discuss with you for a few minutes today, S289, the Vermont Kids Code. I am co-chair along with Carrie Healy, who's also going to testify in a moment, of a group it's a volunteer bipartisan group that we call the Council for Responsible Social Media. And our single and solitary goal is to get federal and state legislation that can help put some needed guardrails around the way social media operates. Americans of all political persuasions are very concerned about unchecked social media. Manipulative social media products are robbing children of their social skills, their childhood innocence, and even causing children to commit suicide. Our children's mental health is at a crisis point. A national poll that we conducted among all Americans found that 84% of Republicans, 83% of Democrats support creating guardrails around social media. 8 of 10 Americans surveyed support federal legislation to protect our kids. The recently unsealed Vermont Attorney General's lawsuit against Meta, formerly known as Facebook, revealed that Meta knows the harm they are creating around kids, but they refuse to correct it. And it's not just Meta. All of the platforms have an extractive business model that has no guardrails. Their algorithmic design code and behavior causes harm to kids. We have mandated safety standards for cars, airplanes, finance, food, and drugs. Why not social media? Kids spend 5, 6, 7 hours a day staring at their phones. Social media is used by 95% of young people aged 13 to 17. It is where they get all of their information. In all my years in Congress, which was a long time ago, I have never seen such bipartisan agreement about the need for action on this problem as I see on this problem. Parents, mothers, fathers, grandfathers, grandmothers are demanding action from Congress and state legislatures. I hope your committee and your legislature can gain passage of S289, the Vermont Kids Code, which can help protect Vermont's kids. Thank you. And I'm now going to turn it over to Carrie Healy, and we'll be around for a few minutes after we testify to answer any possible questions. Thank you.
Thank you, Mr.
Thank you, Leader Gephardt. I'm Carrie Healy. I'm the former Lieutenant Governor of Massachusetts and the co-chair with Leader Gephardt of the Council for Responsible Social Media. And when it comes to solutions, too often the conversation about social media reform focuses solely on content. What types of content are harmful? How should these posts be taken down? Who gets to make these decisions? This is a politically charged debate and one that implicates both Section 230 and the First Amendment. This framing is also a distraction. Many of the social media harms stem from the design of these platforms, algorithmically engineered feeds that endlessly scroll and are designed to addict users. They recommend models that send users down extremist rabbit holes and create patterns intended to point you towards certain features instead of what you would necessarily want to see yourself. Additionally, big tech companies should implement or be required to implement the strongest possible safety and privacy changes by default. Too often, social media platforms respond to criticisms by creating a new tool that can be used to protect your privacy, limit your exposure to harmful content, or mitigate an addictive feature of the website, which places the responsibility for safety on parents or on the user, the child themselves. By calling for safety by design and privacy by default, the Vermont Kids Code serves as a path to accountability for tech companies. It simply requires tech to take a good, honest look at their products and then mitigate the harms and the exploitation of our kids. Recalibrating these features will alter the content that users see automatically on their feed and how they engage with that content. But these changes do not prevent any user from searching or posting content, and therefore it does not limit any user's freedom of expression. Ensuring safety and privacy by design is both the most impactful and the most politically feasible path towards social media reform. The Vermont Kids Code also focuses strongly on data collection, which drives so many of the harms that our minors are facing online. Here's a breakdown of how the Vermont Kids Code will help keep kids safe online. The code requires data privacy by default through data privacy impact assessment requirements, as well as privacy and data protection mandates. The code requires that companies stop selling kids' personal information, stop profiling kids, stop collecting more personal information than is needed to deliver the service from children, stop designing features that are known to be detrimental to kids' well-being, and stop tracking kids' location when doing so is not essential for the provision of the requested service. Companies must set all default settings to high privacy, make it easy for kids to report privacy concerns, let kids know when they're being monitored or tracked, and conduct required risk assessments of how they utilize kids' data. AADCs have been passed in countries around the world. The result of this has been the biggest redesign of tech the world has ever seen. Since the AADC in the United Kingdom went into effect, we've seen important changes that protect kids. For example, TikTok now automatically applies 60-minute screen time limits and stops sending notifications after 9 p.m. Instagram now stops allowing adult strangers to direct message young people. Twitter expands safety modes and blocks accounts that send abusive messages from following a recipient for a set period of time. Snapchat allows users to turn off tracking for content personalization purposes, meaning kids aren't bombarded with recommendations based on profiling. Google has turned on safe search by default, and YouTube has turned off autoplay by default for those under 18. Those are just a few of the hundreds of changes we've seen in since the code went into effect in September 21 in the United Kingdom. Without the incentive to collect more and more data for profit, the incentive for addictive design features will disappear. We can enable our children to develop healthy relationships with technology, ones that allow them to thrive instead of being harmed. The Vermont Kids Code can make that possibility a reality. And this is why I'm urging the committee today to vote aye on S-289. I want to thank you for your time and consideration.
Thank you so much. Thank you to both of you. Those were some really compelling examples from the UK of what this ultimately looks like.
Yeah.
And I really like safety by design, privacy by default. I might borrow that, Madam Lieutenant Governor, if that's okay. I'll start with a question. You both are co-chairing an organization that's traveling the country, it sounds like, and engaging in this kind of advocacy. You see the opposition often. We're going to be hearing more from them next week. And is there anything you would pre-bunk that they might say, or the kind of tactics that they use that you as seasoned elected officials would want to raise for us now to pay attention to?
Congressman Gephardt, would you like to take that?
Oh, Congressman, you're muted, unfortunately.
Sure. Thank you, Carrie, and I'll throw it over to you to give more answer. What we have found is that the platforms have more money than God. They virtually hired every lobbyist in sight to fend off any kind of legislation. And they're very effective at it. And their usual argument is, you cannot stop us from doing what we're doing because it's so important to the American economy and to American competitiveness. We won't compete with the Chinese and others if you tie our hands. It's just a crazy, wrong argument. We got that argument when we tried to regulate automobiles or airplanes or the other things that I mentioned. It's just a specious argument. I voted in the early 90s when I was in Congress for Section 230. And let me tell you what the platform said then. They said, if you don't pass this, which makes us immune from legal liability for any harm that's caused by what's on our platform, you'll never have an internet economy. And then they said, we're just a dumb pipe. We don't create any content. The people worldwide create the content, so we can't be liable for what they say. I voted for it. It was one of my mistake votes in my time in Congress. And what we know since then is that they're the most intelligent pipe in human history. They design their code. They design their algorithms to hook people into keeping their attention on the website so they make more money. That's the way it works. We've got to regulate this, and we can't listen to the pleadings of all the lobbyists that are going to appear before you to talk about why you can't do this.
Thank you.
Yes, I would just add that it is about the money, and that's all it's about. And when you weigh their profitability versus the genuine harms to children that are being created, there's simply no way to compare these two things. We protect our children by law against every other possible danger, in food, in every product that touches them, in their school environment. We go out of our way to use our laws to protect children. And so it's simply nonsensical to think that we would then allow them to spend hours and hours a day with a product that is actually being designed specifically to loop them into messages that will cause them depression, drive them to suicide, allow them to be bullied to suicide, to allow them to be sexually exploited. And the platforms have visibility into all of this. They understand that they're creating an unhealthy relationship with many people in their bodies, both men and women. And they know that they can profit from this over time. So I think it's very reasonable to push back on these very large, very profitable companies and say, you can certainly have the patronage, the attention, the natural attention of young people, just so long as you are not harming them. And when they are adults, you can interact with them with like any other adult. But right now, as children, they need to be protected.
If I could just add one anecdote, we have 3 mothers on our council whose kids killed themselves. One of the mothers at a recent meeting told me her story. She said her son, 14, came to her with his phone and said, "Look at this, Mom. This is funny. She said, what is it? He said, it's the choke challenge. She said, don't get involved in that. That sounds dangerous. He said, oh, I never would. 5 days later, she found him hanging from his belt in the garage, dead. The way it works is if I'm a kid and I start searching for information on teen depression or cutting myself or eating disorders, they drag you through their algorithms into websites, into features that drag them toward committing suicide. She said hundreds of kids are committing suicide because of this algorithmic behavior of these platforms. So this is not just a theoretical issue, this is a real issue, and people are suffering from this all over Vermont and all over the United States.
And if I could just also add that I'm a former college president. I was president of Babson College in Massachusetts for 6 years. And the 6 years that I was president were the years when social media became available to young people for the first time. I came in 2013, and social media was integrating these platforms that targeted young people in negative ways after 2012. And I saw the mental health of my student body deteriorate over those 6 years. And I was baffled. I had no idea the correlation that was occurring between their growing social media use and the total deterioration